Welcome to another episode of Culturally and Technically Legal with Josh Walls, where we examine the intersections of culture, law, and technology. Today, we have a very special guest, one of the best young litigators in the city of New York. Matter of fact, not just the city of New York, but in the whole country, Miss Kamille Stewart. How are you?
I am good, Josh. It's such a pleasure to be on here with you.
So happy to have you. Obviously, we got a lot of different topics to talk about. Just where you're at in your career. You know, you're really just killing it all over, and I think it's great to share that with the world and give us a great understanding to the role and task of litigator. But before we jump into that, just want to know what made you want to go into this space of litigation. How did you jump into this place? Was this something you were always interested in, or is this something that just came all about?
Yeah, first let me say you're really putting a lot of gas in this tank, like a battery in my back. I'm working on it, but appreciate you. And so, to be honest, I feel like I kind of fell into that. In terms of coming to the law, like I was always good at reading, writing, and speaking, and I wasn't good at chemistry in college, so I gave up on my med school dreams and decided to go to law school. But in terms of litigation, like I've always enjoyed stories, and a part of litigation is telling a story, and so that really made those type of roles appeal to me. So I did, the trial ad in law school, and then thankfully my first role was just really in civil prosecution. So it was just trials every day, and then just
Right.
got used to that.
Okay, no, that's interesting. And you talk about telling a story. Um, Obviously, there's different lawyers for different things, right? You have corporate business lawyers. You have just lawyers in all different ways, right? And you see that if people watch this podcast. What's the difference between a litigator and any other lawyer, or what you do? How is that different from what other lawyers do?
I don't like this question. Mainly because I feel like a good lawyer has to be a mix of both. But
Okay.
primarily when talking about a trial lawyer, they're focused on jury trials, right? Like they're usually stereotyped as very charismatic, very eccentric, but know how to connect to the jury and know how people's minds work and how do I get to these people to a yes. But they may not be the best on the law. They may not be the best on these different areas. Um, and that's a stereotype, but like I said, I think you should have a good mixture of both. Whereas litigation, or most litigators they'll do trials, but it'll be bench trial, right? And so bench trial is just you and the judge, and the other side. So you're making your arguments, you're presenting your case. It's also about like getting those motions in. Maybe I get that motion dismissed or summary judgment motion, things to kind of resolve the case before it has to go to trial.
That's interesting. So it's kind of like you're really out there as an extension of your clients or whomever you're working for. To your point of the importance of being able to tell that story. How are you able to build that story up? Like, what things are necessary, right? One, from the client aspect, and just from the general your day to day work to really create that story that you need for your client to win a case or have a result that they're interested in.
I think the first biggest step is to know your facts, right? Like it's hard to tell a story if you don't know everything that's going on. And then the next part is knowing your audience, right? Like what will appeal to them. And so like in a civil context versus a criminal context, you're thinking about, okay, well, what is the societal view on this? He or she did this particular crime. Can I, what can I do with that? If I'm the defense, like how can I defend against something that might not be uh accepted or defensible, right? Or on the civil side, okay, they might see my client as this big corporation. Do they have any sympathy for me? Probably not. So how do I get across that this is more than a business decision and you really should find in a way that is beneficial to my client? So
Yeah, that's extremely important. Just I guess knowing your client and how important that is. And just I wanted to ask you about the stages of litigation, but before we jump into that, I think you brought up a very important point, right? You talked about understanding your client, knowing your client. But even with you, there's a set of rules that you have to abide by in court spaces, right? In legal spaces, being a lawyer in general, right? You have your rules of professional conduct, and then you also have your civil procedure rules. Can you talk a little bit how these are guiding forces for you in the court and what they create, whether it be attorney-client privilege with the rules of professional conduct or civil procedure, how you can act in a court or when you can speak and when you can't speak? Could you shed a little bit light to people who may not really know about these guidelines that you have to follow within the court system and with clients?
So essentially, when you become a lawyer, you do take this oath, like you're becoming the officer of the court, right? And so since you are an officer of the court, when you make statements, when you say something to the judge, they're holding you to that. So one of the things that comes up in civil procedure and things you can get sanctioned, which is basically punished for, what that might look like a monetary or an admonishment, like the judge, publicly putting you down for something, is if you file something like this is frivolous, like you wrote nonsense in here, like this is not true, like you wasted the court's time, the public's time, right? Or in a criminal setting, as a prosecutor, you have an even more stricter standard of, as the prosecutor, you have to make sure that if there's Brady material, right? So anything that might be favorable to the defendant, or sorry, I should say the accused at this juncture, anything that might be able to exonerate that person, you have to present that. You also need to protect the record and make sure that it's clear. In terms of rules of professional responsibility, that's a lot about the client and attorney relationship, like how, are you keeping up with the calls? Like, are you ignoring your client? Like, how do you manage funds, right? So, are things going into your account when they shouldn't be? Like, are you commingling money that should be separate? How are you handling your client's finances? So it's just different things that are really keeping you up to this moral standard, slash a code of ethics to make sure that the right thing is done.
Yeah, people don't realize how important those things are because without those, those structures or those rules of conduct or professional responsibility, I should say, or even that sole procedure, it could affect the case long term, right? And in that, could you talk a little bit about the various stages of litigation, right? Because I think sometimes we watch television or we watch in the media or anything like that. We watch these big news channels and it's like, oh, so and so has happened to this person, but then we don't see a trial happen for a while, or we don't see, anything, happen like we see on fictional TV. Something happens, there's a trial within the next 2 minutes of the show. Talk a little bit about the actual stages that you even have to go to, and where does the trial stage fall into this when we're talking about litigation?
For sure. So unlike Law and Order, it does take a lot longer than 30 minutes. So on the criminal side, it starts with an arrest, right? And some jurisdictions, it may be the police officer or sheriff who writes the complaint. But in New York City, at least I can speak for, it's the prosecutor's office who drafts the complaint, right? And is responsible for processing an arrest after the officer brings that in. Then after that, there's an arraignment. Essentially, the judge tells the accused what the charges are against them. These are the charges against you. And then you will either be, released, supervised release, or you're held in, or any number of combinations of that, right? Whether it's bail or some other alternative. And then you'll have a bunch of appearances before you actually get to a stage of trial. On the civil side, if I'm a plaintiff bringing an action, I have to make sure I serve a summons and complaint on the other side. And depending upon what court, like, these filings to start the action costs a pretty penny. So it could range anything from $15 in small claims court to $400 for federal court. So you pay that money, then you might pay another set of money for what's called a request for judicial intervention. Basically, judge, we need help. We need to decide that. So I have to pay an additional set of money for that. So that I'm mentioning those things because sometimes, especially in a civil context, a case may take longer if I don't have the upfront monies to kind of really push this litigation forward. And like literally anything you file costs money. So it's a motion, some papers, it costs money for you to file that. And so the things that when we talk about litigation costs or why things are taking long, it could just also be the money as you go. But getting back to your question in terms of like what are the different stages, so like after you file this complaint on the civil side, the person has an opportunity to respond, and that may go in, then you might have a conference depending upon what judge or what court you're in. They might want to just hop in right into a pre-trial conference and kind of really map out your discovery, map out what are if they want status conferences, map out if they want a settlement conference to come up based on the numbers are really low and I just want to get to the end of this, right? So it really depends on where you are and what the context of the case is. And then depending upon discovery, right, you might be stuck there for a while. So when I know in the news right now we have like Trump going to court and whatever, different things. Like, so prior to even before that, like at some point there probably was a deposition taken from him, and that's essentially the person being questioned, and it's recorded, and their attorney can be there, and they're responding to those questions. Or maybe the discovery can also look like, I sent you interrogatories, and basically those are like a question and an answer. Like, I give this question, you have a response, or an ability to make a written response. And then the request for admissions was just essentially like, all right, we know this is true. We don't have to litigate on this. So we'll usually just ask this very direct thing, that anticipating that you will agree and that we won't have to go over that. So that's the request for admission. And then it could just be turning over documents, right? And depending upon the case, like if it's thousands of documents, that might just take a long time, right? Just based on data. Or if it's still physical, depending on how far back the case goes. So just discovery alone, I mean, sometimes it can take a year, 2 years, and you haven't even made it to trial yet, right? So like, it's definitely not 30 minutes we see. Yeah.
So that's interesting. You said it could take up to 2 years or so like that. Is that sometimes the reason that some parties just decide to settle? Or is there, I mean, I'm sure there's various reasons that people decide to settle. But, when I was younger, I used to watch, different things, and maybe a celebrity that I was interested in following, they're like, he just settled outside of court. And for some reason, I was like, oh, he must have been guilty, so he didn't really want to go through with it. But that's not always the case. And could you just shed light on, like, how frequently people actually do settle outside of court? How much of a
Yeah.
norm it could possibly, or it is possibly a very normal thing, and some of the reasons as to why people actually do these settlements.
So I would say the majority of all lawsuits, maybe we could even say 65 or 70% settle. And that's true for both civil and the criminal aspect too. Like, people plea out, right? And what on the civil side, you're weighing time and money. So an expert to usually has a day job. And so if I want this doctor to come in and testify for me for a personal injury case, I can pay upwards of thousands of dollars per hour. And so the question becomes, is it worth it to have, this orthopedic surgeon in here, and it's going to cost me $10,000 a day, depending upon, we might not finish testimony today and I got to do a second day. I'm thinking about the money and the time, right? So if we're doing all this discovery sharing, if it is something that is super complicated and it's going to take me that much longer, and sometimes the need is immediate, right? Like, your client might want money today, right? Like, or tomorrow. And if someone's offering some sort of settlement of money immediately, I might want to take that. I got bills to pay. Like,
Right.
I've already been working in the red. Like, I need to make up that cost. On the criminal side, there can be reasons on both ends for both the prosecutor and defense why a plea might look like the best option. One, it can be, maybe my record is not that great, and being able to plea down to a misdemeanor helps me out. For the prosecutor, it might look like, certain programs, um, depending upon what crime you are ultimately convicted with, might not let you in. And if we've discussed, we being the prosecutor and defense, said, okay, I really want this person to be rehabilitated. But that program won't allow him or her in if they, get convicted of this particular crime. All right, how about we do this? He pleads down to the misdemeanor, but he enrolls in this program, and this is their step towards, getting rehabilitating and getting back into society. Um, or I can, the thoughts might just be, all right, do I really want to go through a jury trial on this? And really be tried in the court of opinion, right? Especially like when we talk about our criminal justice system, the pendulum swings from very conservative to liberal very frequently.
Oh yeah, yeah.
And so, do you want to be the person bringing you to trial when the day after George Floyd? I don't know.
Right.
Like maybe we just offer the misdemeanor on this one and cut it a loss. So like there's just certain things that we you think about, and those are considerations, and for the defendant or plaintiff or whomever it benefits, settlement might be the better option.
That's interesting, and obviously, technology is ever growing in just any space, right? Industries in general, right? So we think about the legal industry as a whole, where some automation has actually taken place. Do you think there's a space, or have you used it in your day to day, where artificial intelligence or generative AI has been able to help you in what you do at all, or do you not use it, or is there plans on using it in the future, right? Whether that be briefing cases, whether that be trying to find a resource to kind of use as a from a citing standpoint when you are looking at newer cases. Just have you seen it all, or do you plan on seeing it in the future? You think?
So I'm really a Flintstone when it comes to technology, but I will say it's one of those things where even if I wanted to ignore it, I can't.
Right.
So, we're having constant conversations around, okay, this is how AI is going to revolutionize how we keep our data, how we store certain things. So, like, the company is already moving along and trying to figure out ways to incorporate this, because especially if you're selling a product or you're offering a service to these various business partners or customers, and say I work for an insurance company, so if another insurance company, Prudential, Geico, is offering these services and MetLife's not, well, we're behind. So
Right.
that is all to say, even if I don't want to, the industry's already automating or already moving towards that. Now, I think there's certain things within the legal field that I'm just vehemently against being AI. Like, I've heard about, you know, at some attorneys already using AI to write a brief and citing, oh, well, I found this information on AI, and like that, using that as a citation and it being incorrect, right? Like, that's like, there's no excuse for you not doing your own research, right? So, and at the end of the day, I think you do have a duty to your client, um, to make sure what you're putting in is accurate. So even if you do use AI, you should be checking, right? All that to say, I haven't been mandated or told I have to use it yet, but I assume that at some point we're all going to have to touch it in some way.
Right. No, that makes a lot of sense to me. And just to go a little bit back to kind of some of the stuff you were talking about earlier, something, and I keep talking about these personal media interactions and TVs that I watched, the cultural phenomenons, but something I think one of the first ever phrases that I ever got familiar with when it came to law was I plead the fifth, right? Whether you see it on TV shows like Martin or some of the more contemporary reality shows. Could you give us a breakdown of like what that truly means? In addition to that, do people only use this because they're guilty, or is it sometimes other reasons that you could use that phrase, I plead the fifth?
Yeah, so when you're talking about I plead the fifth, you were talking about the Fifth Amendment of the Constitution, which essentially protects your right to silence and also affords you an attorney. So that that language that kind of goes around in your head if you watch Law and Order or certain shows of, you have the right to remain silent. Anything that you say can and will be used against you in the court of law. You have the right to attorney. If you can't afford one, one will be provided to you, right? And so when someone invokes that right when they're on the stand, what they're saying is, I would like to remain silent. Now, the judge then is supposed to give what's called curative instruction. And so what that means is they'll say to the jury, hey, this person has a constitutional right to assert, to not say anything that may or may not be incriminating, and you're not allowed to make an inference against them. Now, we all know that once the person has said, I plead the fifth, the jury already, oh, he did it, they did it.
Mm-hmm.
So
Mm-hmm.
there's no way to take that back. But at the end of the day, it is a right and you are allowed to assert it. I think some of the things that um, persons are thinking of is, no matter what answer I give to this question, you're going to already think. something, right? So for instance, I asked you a question of, were you there that night? And I may be innocent of the crime, but the answer to that question already builds up, oh man, they got me, or I may be protecting someone or whatever. There might be other considerations that I'd rather just not answer at all, because I'm having such a hard time. This examination has been so combative that anything I have said has been turned against me, and I'm almost scared to answer, right? So like there could be a number of different considerations, but a lot of it is, all right, if I answer, will this be used against me and how? And so might be more strategic to be
Makes
quiet.
sense. Makes sense. And before I let you go, just one last question. What advice would you give to someone who's aspiring to be a litigator, and what piece of advice would you also give to someone who's in the process and looking to hire a litigator?
I think for anyone trying to get into litigation, get in the courtroom, right? So whether that looks like you just going to see trials, like most courts proceedings are public, so you can just drop in, like even some of the more I would say famous or more public trials, like those are still open to the public. Now, seats might be filled with press, but if you can do so, just because you want to see how other people do it. And then you want to be able to develop your own style of, how do I tell a story differently? How do I connect differently? And you want to see when it doesn't work either, right? So sometimes the best thing has been for me seeing that didn't go over well, right? Like him screaming or her screaming didn't really connect with the jury, right? So it's things that you pick up on by just being in the courtroom. That can also look like you taking on externships, doing trial ed, just working on those skills of being able to think on your feet, formulate arguments, and like I said, make that connection if jury trial is what you're looking at. In terms of, can you repeat your last question one more time?
Just advice you would give to someone who's going into litigation and looking to hire a litigator.
I I would say for someone looking to hire a litigator, um, as a not to judge a book by its cover, like some of the most quote unquote like demure or reserved looking attorneys have been more successful, because sometimes even the more gentle you are in telling your story connects more than the person who's kind of very boisterous or the stereotypical trial lawyer. Um, and for someone, like I said, looking to get hired as a litigator is make connections in addition to the make sure you find ways to be in the courtroom.
No, that was some sound advice. And we want to thank you again for joining us. Really, really great conversation. A lot of insight, a lot of gems was dropped. Looking forward to just kind of unraveling what you said and starting to apply it. So thank you a great deal for just spending some time with us today.
For having me.
No doubt. That was another episode of Culturally and Technically Legal. Thank you guys so much for watching. Please stay tuned for the next episode. Have a good one, guys.